Good afternoon, ladies and gentlemen. Welcome to yet another segment of BW Legal World's Saturday Solutions, where we speak with experts on hot legal topics and the latest legal developments. And today we are discussing the Insolvency and Bankruptcy Code, understanding the CIRP process and its elements. Let's welcome our August panel for the day to take the discussion ahead. We have with us Madhav Kanoria, partner Cyril Amarchand Mangaldas, Kunal Tandon, Counsel, Delhi High Court and Supreme Court of India, Manisha Chaudhary, Managing Partner, UKCA and Partners, Yogendra Aldak, Partner, Lakshmi Kumaran and Sridharan. I'm your moderator for today, Kaustubh Mehta, Editorial Lead, hoping to get you as many insights from our experts in the next 1 hour. We have just learned that Manisha Chaudhary may not be able to join us due to sudden exigencies. We wish them well and move forward with our session. So experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. So let's dive right into the conversation with our panelists. Panelists, before we go to our Q&A round, could we have a brief precursor to your thoughts on the Insolvency and Bankruptcy Code? Yogendra, your thoughts, please.
Thank you, Kaustubh. So, as far as IBC is concerned, the need, why we needed a legislation like IBC is evident from earlier enactments wherein there were multiple enactments for multiple entities. For example, we had Companies Act, Cirp, then other acts relating to corporate entities. Then we had, in fact, we now have colonial legislation with respect to individual insolvency and proprietorship concerns going to insolvency. There were multiple legislations, there were multiple forums, and there was no watchdog as far as the insolvency process is concerned. So considering all these parameters, the time which required for the resolution of insolvency, it was very long. And that resulted in the delay, that resulted in lower value of the assets of the corporate debtor. Considering all these things, the need arose for a comprehensive legislation for which the Law Commission report were there and proposed IBC. Now, as we see, IBC not only take care of corporate entities, it also take care of the individuals' proprietorship concerns, and in a way, it has streamlined the forums and the process. So this is as far as the advent of IBC is concerned from my side.
Kunal, your comments on the IBC?
Yes. Taking forward from Yogendra, I personally feel that IBC brings in a concept of creditor in possession of the control rather than debtor in possession. All the earlier legislations which we had, it was more or less the company or the management continued in possession, and whereas the IBC, the major shift is that the creditor has come in possession as and when the process of IBC is triggered. Now that is point number one. Point number two, according to me, it provides, and what Yogendra also said, that it provides a one-stop shop for all issues, and the Parliament has been alive to the issues faced by various companies from time to time, where they brought in amendments to kind of iron the creases of IBC which were needed, and most important of it was 29A, which barred the promoters from coming into the resolution process, and secondly 32A, which gave primacy and immunity to the new management. So I personally feel that IBC is an enactment which brings in a lot of confidence amongst the investors, and if it works properly, this is the way forward for us.
Thank you, Kunal. Madhav, your insights.
Thanks, Kaustubh. And Yogendra and Kunal have already covered, like set the tone for what IBC has achieved, and not adding any nothing further to add for setting the platform for IBC. But as Kunal said, that the biggest shift has been that earlier when there was a winding up regime, there was SARFAESI, there was SICA. So all these, in a way, were dealing with the problems which IBC seeks to address. The major shift has been that all those things, for whatever reasons, like we always hear that the court system or tribunal system is flooded with cases. There are so many pending cases, and to some extent that was being taken advantage of by defaulting borrowers, promoters, so to speak, to game the system, so that and as a result, creditors were not able to recover their money or have any resolution. What IBC has done, the paradigm shift, is that from day one, if there is a simple thing, if there is a default and your form is there, then an IRP is appointed who takes over the management of the company. And that is the major shift, because from day one, you lose control. Then it becomes very difficult, and then you form part of the process. So that mindset, and we keep reading in newspapers that because of the threat of IBC, so many one-time settlements have happened, so many other forms of settlement outside of the IBC mechanism have happened, where the entire banking system, like major part of it, I must say, has been cleaned up. So the NPA problem, which we have been hearing since 2009, 2010, has been plaguing the banking system, has been to a large extent solved because of IBC. And that is reflected in the fact that most of the public sector banks, also private sector banks obviously, but public sector banks are in the black after a long time. So they are actually able to declare profits and show that they are doing well, and that is and that works well for the economy as a whole. The second major advantage has been the enforceability aspect. So contract enforcement has always been a problem in India. Like in the ease of business rankings, for example, published by the World Bank, India used to rank very low in contract enforcement, and the reason was that we have arbitration mechanisms, we have the court system, and everything was being taken its own time. But with IBC and the threat of IBC and the way you end up losing control of your company, of your asset, that has also been a major booster for contract enforcement, which is reflected from the increase in or rather the improvement in the ease of doing business in India rankings. So this has been the major advantage for IBC, I would say.
Right. Thank you, Madhav. So let's begin with our next segment, which is the descriptive questions. So my first question would be to you, Madhav. Who can initiate a corporate insolvency resolution process?
Thanks, Kaustubh. So as I said, the trigger for a corporate insolvency resolution process is a default. And default is when a debt is due and payable but remains unpaid. So it could be an interest installment, it could be a principal installment, it could be any other contractual debt or an invoice which remains unpaid. The threshold was earlier 1 lakh. Now it has been increased to 1 crore in 2020. As far as a corporate debtor is concerned, so a corporate debtor is a company or a limited liability partnership. CIRP, corporate insolvency resolution process, can be initiated by 3 kinds of persons. One is a financial creditor, that is your bank or financial institution or any person who has given you a financial debt. And as we are all aware, home buyers also fall in that category as financial creditors. No notice is required by a financial creditor to initiate, and you can just, if there is a default, you can file in the prescribed format before the National Company Law Tribunal and prove, and so to speak, prove your debt and default, and then it will be admitted. Second category is an operational creditor, which is any person who provides goods and services and includes government authorities, statutory authorities, and employees and workmen. they can initiate insolvency proceedings against a corporate debtor. The prerequisite is that a demand notice has to be sent by an operational creditor. 10 days time has to be given. So there is a format prescribed for a demand notice as well. It has to be sent to the corporate debtor and to give them 10 days to respond to it. Either they can raise a dispute, which has to be a pre-existing dispute, which they say that the goods were not up to the standard, or the services were not up to the standard, or the contract is not there, or there has been a breach. So all those kinds of disputes, or some arbitration is pending, some court proceedings are pending, or make the payment as per the demand notice. If either of the two does not happen, then the operational creditor can file an application before the NCLT again. The difference between a financial creditor and operational creditor is a financial creditor has to give the name of the interim resolution professional. An operational creditor is not required to give the name of the interim resolution professional while filing its application. The third category is the corporate debtor itself. So it is akin to what is there in other jurisdictions, where a company which is in default for restructuring and rehabilitation and revival from its as sort of a negotiated settlement with its creditors can initiate insolvency against itself. So any person authorized by the articles or memorandum, or any person who's in charge of the affairs of the company, the financial affairs, or supervises the operations of the company, can initiate the application. The threshold is the same, that is a default of 1 crore in financial debt or operational debt. For a application by the corporate debtor itself, you need a special resolution passed by the shareholders or the partners, as the case may be. And in this case also, you have to propose the name of an interim resolution professional. Now, just a few seconds more on financial service providers. So financial service providers is also a category under the IBC, like your NBFCs. We have seen Dewan Housing, and now the Shrey companies and Reliance Capital. So these are also covered under the IBC by way of a notification by the central government in 2019. And for initiating CIRP vis-a-vis these companies, only the RBI currently, so it's only been notified with respect to NBFCs, but only the RBI is empowered to file a Section 7 proceedings on account of a default. No financial creditor, no other financial creditor or operational creditor can initiate insolvency. So that is the only difference as far as financial service providers are concerned.
Thank you, Madhav, for those nice comments. Let's move on to Kunal. Kunal, if you could elaborate on the initiation of CIRP by a financial creditor.
Yes. So I think Madhav has set the tone for how the insolvency resolution process is initiated, because he's talked about Section 7 petition and Section 9 petition, etc. I think I will move on from initiation and give a stepwise details of how the CIR process is taken up after admission by the adjudicating authority, which is the National Company Law Tribunal. According to me, there are in principle 5 or 6 steps, though it is very difficult to give each and every detail in just 2-3 minutes. But let me give in principle 5 or 6 steps. First, obviously, is initiation. Second is when the adjudicating authority declares a moratorium under Section 14, which is upon finding that the amount which the financial creditor is claiming is payable and undisputed. Third is the step where the interim resolution professional publishes about the moratorium of the corporate debtor and calls for formation of the committee of creditors. So that is one of the most important steps in the entire process. Third important step, and after formation of the COC, is that there has to be a confirmation of the IRP into the resolution professional. Then fourth or fifth step is the disqualification check and invitation of resolution plans which come upon for taking over the corporate debtor. And last is the approval by the Committee of Creditors before an application is filed for approval before the adjudicating authority. So these are the 5 or the 6 steps which, according to me, go through in the CIR process. So this is catered to by Section 7 till about Section 31 of IBC. So these are the steps really which need to be looked into. Now, coming back to the first step, moratorium is issued under Section 14. A 330-day period is given for completion of the corporate interim resolution process. After 330 days, on exceptional grounds only, the period is extended. Then comes the rights and duties of the interim resolution professional. As Madhav said, that along with the application under Section 7, there is a Form 2 which has to be filed, where you have to declare your own interim resolution professional who is to function for about, I think, 30 days, before which the confirmation takes place by the Committee of Creditors. Coming to the Committee of Creditors, as soon as the Committee of Creditors is formed, Committee of Creditors can either accept the same interim resolution professional and make him the resolution professional, who then carries forward the entire process, or they can change with 66% voting in the COC and get a new resolution professional. Then coming to the issue of resolution plans, it is the duty of the resolution professional to call for all the resolution plans. He issues an information memorandum, expression of interest, etc., within a time-bound period, and then calls for all these plans. And these plans are firstly looked into by the resolution professional himself before it is placed before the COC. COC thereafter looks into these plans. They are also entitled to negotiate with the resolution applicants. Out of, let's say, 2, 3, 4 resolution plans which come before the COC, after checking the feasibility and viability of those plans and taking into consideration as to what the corporate debtor is all about, what kind of business it is doing, etc., background of the resolution applicant, they then vote upon it. Now, 66% is required for the plan to be approved. Thereafter, upon approval by the COC, the plan is put before the adjudicating authority. The adjudicating authority's role is very limited, where they are to look at compliances under Section 30, whether Section 30 is complied or not. Section 30, while it is very restricted, but subsection 2 of Section 30 lots of time creates a lot of issues where the objectors, who could be the dissenting financial creditors, come and say that equality principle has not been adhered to, or 30 subsection 2 liquidation value has not been adhered to, or liquidation value has to be the liquidation value of the securities which belong to those objecting dissenting financial creditors, etc., etc. These are the kind of objections which can be taken, but it is very limited. Thereafter, after the adjudicating authority hears the plan approval application, it has 2 options. It can either reject the plan and put the company into liquidation, or it can approve the plan and allow the new resolution applicant to take over the working of the corporate debtor. Once that is done, there is also a procedure of monitoring the working of the resolution plan. That's also provided in the resolution plan itself. It could be for a period of 2 years or so. So that's how the process of CIR is generally taken up from Section 7 onward till about Section 31. So, yeah. Of course, there are appeals provided to NCLAT, Supreme Court, etc., but that I'm not going into at the moment.
Thank you, Kunal, for that great overview. Now let's get into the nitty-gritty of the Act. Yogendra, what is a claim under IBC? And if you could explain our viewers the process of verification and analysis of claims.
Thank you, Kaustubh. So just adding to what Kunal and Madhav pointed out, as far as claim is concerned, it is very widely defined under the code. If you see the definition, it clearly says claim means right to payment or right to remedy on account of breach of contract. And this right, it can be reduced to a judgment, it can be legal, it can be equitable, it can be secured, unsecured, disputed, undisputed. So the way the claim is defined under the code, that is very wide. Now, question comes, at the time of filing the claim before resolution professional, is there any requirement to submit documentary evidence to establish the claim? The answer is yes. For different applicants, be it financial creditor, be it operational creditor, be it other creditor, the regulation prescribes documentary evidences to support the claim submitted by the operational creditor or financial creditor or any other creditor. Now, when we say documentary evidence, taking for example, the documentary evidences required by operational creditor to submit, if you see regulation 7, it clearly says the claim will be supported by an information available with information utility. Then it says, or other relevant document, including, so here it gives a very wide picture. It says, or any other relevant document, including 1, a contract for provision of service or good, 2, an invoice, 3, any order of the court or decree of a court, and then it says, or 4, which is financial accounts. Now, the question which arose was whether the operational creditor is required to submit just one document mentioned in the regulation 7, or it is required for the operational creditor to enclose all the documents mentioned in the regulation. The word which is mentioned between subclause 3 and 4 is or. So in the recent judgment of Supreme Court in consolidated construction, it has held that any one document submitted along with the claim will be good enough for the resolution professional to consider the claim. Now, the question is, if a resolution professional is taking care of all the claims, what are the powers given to the resolution professional? The power of the resolution professional is very limited. It is only to collate, verify, and collect the claims. This is as against the power which is given to a liquidator. Liquidator is given the power of adjudication. The liquidator can adjudicate upon the claims, whereas the IRP or the RP, they cannot. Now, the another question which comes, that just in case a claim is either partially rejected or completely rejected by the resolution professional, what is the recourse available to the applicant? The recourse which is available is further provided under the regulation 14, which clearly says that on account of additional information brought to the notice of resolution professional, the resolution professional is empowered to revisit the claim. So if a claim is, let's say, partially rejected or completely rejected, the operational creditor can go to the resolution professional for revising the decision taken by the resolution professional. In case, let's say on the first count, the resolution professional declined to admit the claim or partially admitted the claim, or on the second round, he declined to revisit the decision taken, what is the remedy available to the applicant? The remedy available is to file an application before the adjudicating authority under section 60 subsection 5, wherein the same can be considered by the adjudicating authority. Now, if you see in current scenario, to my understanding, a substantial litigation before NCLT is with respect to these applications. If these applications are decided, then definitely a major chunk of litigation will go down from NCLT.
Thank you, Yogendra. Let's circle back to Madhav. Madhav, how does the appointment of the resolution professional take place, and what is his tenure?
Thanks, Kaustubh. So as we have discussed earlier on this session, a financial creditor, when they are filing an application, are required to propose the name of an interim resolution professional. And same is the case with the corporate debtor itself. If they are initiating an insolvency petition, if they are filing an insolvency petition against themselves, an operational creditor is not required to propose the name, and the NCLT can appoint. So how it works is, when the NCLT admits the application or / petition filed by the person initiating the application, and admits the application, that is, and passes an order for commencement of CIRP process, they also appoint the interim resolution professional. If the name proposed by the financial creditor or the corporate debtor, that person is not subject to any disciplinary proceedings by the Insolvency and Bankruptcy Code of India, their name will be confirmed, or there is a panel with every NCLT from which they choose a name and appoint the interim resolution professional. The interim resolution professional's tenure is for the first 30-35 days, before which they have to, during which time they have to collate the claims, as Yogendra and Kunal have said, and they have to form the committee of creditors. That is one of the primary duties of an interim resolution professional, to constitute the committee of creditors comprising of all the financial creditors who are not related to the corporate debtor, and then convene a meeting of the first meeting of the committee of creditors. In the first meeting, what the code provides is that the interim resolution professional's tenure is up to the first meeting. At the first meeting, the committee of creditors can either choose to confirm the same person as a resolution professional. So the difference is, the earlier one is an interim resolution professional with the same duties and responsibilities as a resolution professional, but the main duty being the constitution of committee of creditors. And then they appoint the resolution professional who will run the subsequent process in the CIRP, as part of the CIRP. Or they can choose to replace the interim resolution professional with a new resolution professional who is registered with the IBBI. In both the cases, the committee of creditors is required to intimate by filing an application to the NCLT that either they have confirmed or chosen to replace. This is at the first meeting. What the code also provides under section 27 is that at any juncture in the CIRP process, the committee of creditors, if they deem fit by a 66% majority, can replace the resolution professional. So it could be on the 150th day, it could be on the 180th day, it could be on the 250th day. At any point in time, the committee of creditors can replace a resolution professional and appoint a new resolution professional. There is jurisprudence, settled jurisprudence, that the committee of creditors is not required to assign or ascribe any reason for the replacement. So it is, there could be various reasons for which a RP is being replaced, but you are not required to put that in an application or give any reason to the NCLT. Once the committee of creditors passes a resolution with the requisite majority, then again they have to intimate the NCLT by filing an application proposing the name of the new resolution professional. So this is on the appointment of resolution professional. And as far as tenure is concerned, so a resolution professional is required to conduct the entire CIRP process, right from the day of his appointment till the date when either a plan is approved by the NCLT under section 31, or a liquidation order is passed by the NCLT under 33, and a liquidator has been appointed under section 34. Earlier, and this has been inserted by way of an amendment. Earlier, the process was that the RP used to function for the CIRP period. Now, the CRP period is initially 180 days, extendable by a further 90 days, and with the subsequent amendments for a maximum period of 330 days. And as Kunal said, in exceptional circumstances, it can also go beyond 330 days if there is a chance of resolution there. And we have seen several cases where it has been extended beyond 330 days. So by way of an amendment to section 23, the Parliament clarified that no, it is not only for the period, but until an order is passed. So until there is a final culmination of the CIRP process, the RP has to continue to manage the affairs and operations of the company and of the corporate debtor and maintain the corporate debtor as a going concern. So all the duties like preserving the value of the assets and managing the operations and doing all the other formalities fall on the shoulders of the resolution professional until a plan is approved or a liquidator has been appointed.
Thank you, Madhav, for your comments. Let's circle back to Kunal. Kunal, as Madhav has given an overview about the resolution professional, if you could delve something more on the duties of a resolution professional and how does he go about it?
Yeah. So I call the resolution professional as the ringmaster because he's the one who guides the company or the corporate debtor throughout the process of interim resolution process. His job is mainly to ensure, protect, preserve the corporate debtor and run it as a going concern. So, I mean, you can call him the ringmaster, you can call him the CEO of the company, or you may call him whatever. He's the head of that company during this 330 days or whatever time is provided. So whatever is needed to ensure that the company remains as a going concern, those are his duties. Now, those duties can be divided into two parts. One part is that where he can himself run the entire show and he doesn't need to go to any committee of creditors. And the other part is where he needs to go to the committee of creditors for the purposes of doing something more than what is required. So, for example, for protection of the assets, he can take all kinds of actions. For representing the corporate debtor with third parties, for completing the contractual obligations of the corporate debtor, raising interim finances, of course, that is subject to approval of the committee of creditors, appointing accountants, legal professionals, other professionals for the purposes of completing the work of the corporate debtor, maintaining the updated list of claims, attending and convening all kinds of meetings of committee of creditors, preparing information memorandum, calling, declaring the expression of interest for the purposes of resolution plan. So, all these activities have to be done by the resolution professional, keeping in mind that his job is to ensure that some resolution applicant comes and takes over the corporate debtor as a running concern. So that is what is provided, which he can do without approval of committee of creditors. And there are certain aspects where he needs approval of the committee of creditors, for example, raising finances, for changing the memorandum and articles of the corporate debtor, etc., etc. Those are enumerated under section 28 of IBC, which is there. One can look at that. So basic purpose is, if you're doing something which falls within the realm of decision making of the board of directors, that must go to committee of creditors, because committee of creditors starts in a way acting as a board for that corporate debtor, and anything which the management can answer and take care, that resolution professional can continue doing to keep the entire company as a going concern. So that's the basic concept of duties of the resolution professional.
Thanks, Kunal. Yogendra, now circling back to you, explain the process of submission and approval of the resolution plan.
Thanks, Kaustubh. As already touched upon by Kunal, as per section 29A, there are certain parameters which are required to be fulfilled by the resolution applicant. Now, the reason for these parameters, which we can call eligibility criteria for the resolution applicant, the reason is that the unethical person should not be allowed to take benefit at the cost of other creditors. That is one. Second, these persons should not be allowed, or they should be avoided to come into the management of the corporate debtor. So to take care of this, there are certain eligibility criteria which are prescribed under section 29A. Once the eligibility criteria is fulfilled by a resolution applicant, the resolution applicant can submit resolution plan under section 30 before the resolution professional. Now, there are certain essentials which needs to be fulfilled in the resolution plan. The resolution plan should take care of the CIRP cost. It should take care of the dues of the creditors. It should provide the process for implementation of the resolution plan. It should provide the management and operation after the resolution plan is approved. And it should be in accordance with the law. It should not be in contrary to the law. Once these parameters are fulfilled in a resolution plan, the resolution plan is placed before committee of creditors by the resolution professional, and the committee of creditors by majority vote can approve the resolution plan. Now, the question comes, can the resolution applicant attend the meeting of COC at the time of deciding on the resolution plan? The answer is yes. Second question is, can the resolution applicant seek voting rights? The answer is yes, he can, provided he is a financial creditor. Now, once the resolution plan is approved by the committee of creditors with majority vote, the resolution professional will place it before the adjudicating authority for its approval under section 31. When we talk about section 31, there are two things which is already pointed out by Kunal. The resolution plan can be approved by the adjudicating authority provided it meets the parameters provided under section 30. That is one. And second, the resolution applicant is eligible to submit the resolution plan. If the requirements are not met, the adjudicating authority may reject the resolution plan. Now here, there is one difference in these two. It says the adjudicating authority shall approve if the parameters are met. And in subsection 2, it says the adjudicating authority may reject. So at one point, it says it makes it mandatory for the adjudicating authority to approve. On the other hand, it is discretionary on the adjudicating authority at the time of rejection of the resolution plan. This has been considered recently in that Rainbow Paper judgment, wherein it is held that the word may in subsection 2 has to be read as shall. The reason being, wherever an authority is given discretionary power, it should be exercised in a logical manner. It should not be exercised in a whimsical manner. Therefore, the court has held that may should be read as shall. Now, once the resolution plan is approved by NCLT, what is the effect of it? The effect is that it is binding on the corporate debtor, its employees, members, guarantors, other stakeholders. In fact, after the amendment of August 2019, it clearly says that it will be binding on the governments as well. Now, what was the requirement for this amendment? Prior to this amendment, after the approval of resolution plan, it was the stand taken by the government, wherein the government was claiming certain dues from the corporate debtor, saying that the resolution plan is not binding upon the government, though it was argued that government will be included in the last portion which says other stakeholders. That is one. Second, the government also tried to argue that the government could not file its claim before the resolution professional, and the same was not considered at the time of resolution plan. Hence, it is not binding upon the government. This situation was taken care by Supreme Court in few judgments, including SR Steel and Ghanshyam Mishra, wherein they clearly held that the new management should not be surprised with new claims by the government or any other stakeholder. Once a resolution plan is approved, all other debts are extinguished, whether part of the resolution plan or not part of the resolution plan. All the other debts will get extinguished. Basis this, now after the amendment, it is made very clear that once a resolution plan is approved by NCLT, it is binding on everyone. Now, once the resolution plan is approved, the corporate debtor is given immunity from past offenses, provided the management is changed. Now, as Kunal has already pointed out, if any person is aggrieved by the approval or rejection of the resolution plan, what is the recourse available? Definitely, there is appeal provided in the court, which can be filed before the appropriate forum by the aggrieved person. So this is with respect to submission and approval of the resolution plan.
Thank you, Yogendra. Circling back to Madhav. Madhav, can you explain the waterfall mechanism in CIRP process?
Sure. Thanks, Kaustubh. As you're all aware that for liquidation under Section 53, a specific waterfall mechanism has been prescribed. There is no such prescription as such for a resolution plan, except for the fact that CIRP cost, which is a cost incurred or expenses incurred by the resolution professional for running the CIRP process, including the fees to the professionals, fees to the RP, the dues of the employees and workmen, and the taxes and everything have to be paid in priority over all other debts. But by way of reading the Section 30 subsection 2 and the regulations, CIRP regulations together, this is a priority which emerges under a resolution plan. So first is the CIRP cost, which, as I said, covers all the costs and expenses incurred by the RP during the CIRP period. The second is the payment to the operational creditors. And this is because Regulation 38 of the CIRP regulations provides that any amount to be paid to the operational creditors has to be paid in priority under the resolution plan. So, and this payment will include the payments to your normal trade creditors, to your workmen and employees, and to the government authorities, tax authorities, other government authorities. Now, what the law provides is under a plan, they have to be paid the higher of either the liquidation value, that is the value they would have got if the company were to be liquidated under Section 53, or if the plan proceeds were to be distributed under Section 53. So whichever is higher has to be paid to them. Now, earlier the thumb rule was that since the liquidation value in most cases will not be enough to even satisfy the entire claims of secured creditors, so for operational creditors, it would be zero except for workmen for the past 24 months, workmen dues, because they are pari passu with the secured creditors, secured financial creditors, I must say. So that's why in most plans, if you see, and there are judgments also which uphold this, that nil payment was prescribed to operational creditors, but ex gratia some payment was made, like 2%, 1%, 5% of the recovery was given for operational creditors. Now, the recent judgment, which has come out a few days back, where the Supreme Court has said that one has to look at the statute under which the dues for government authorities is arising. And if that the dues are secured, then they have to be given the same treatment as a secured creditor under Section 53. With that, the landscape may change because that is a minimum guarantee to operational creditors. So whatever amount is due and payable to them as per their liquidation value will have to be paid to them under a plan in priority over the financial creditors. So they are at the second level in the waterfall mechanism. The third level are the dissenting financial creditors. So what the law provides for is that if a financial creditor who has a right to vote on the plan chooses to vote against the plan, that means that such financial creditor is choosing for liquidation over resolution. So in that case, they should be paid a minimum of liquidation value. That is the amount that would have been paid to them as per Section 53 if the corporate debtor were to be liquidated. Now, so if it's an unsecured creditor, it may be unsecured financial creditor, it may be zero in several cases, or as per whatever the residual is left after paying off the secured financial creditors. If it's a secured financial creditors, then it will be determined as per its security interest, the value of security, the priority of security, first charge, second charge. Although there are certain judgments which are emerging, and some of them are pending before the Supreme Court, where like in the judgment of Amit Metallics, what the Supreme Court has sort of indicated is that the COC can cram down even that payment. That is directly against the statute, but as law emerges, more clarity will emerge on this point. But currently, there are cases which are happening or which are pending where the COC, in its commercial wisdom, is paying less than the liquidation value to dissenting financial creditors. It is also complicated by the fact that under liquidation, there are some certain NCLAT judgments which say that once a creditor relinquishes a security, then everybody becomes pari passu, and whatever is recovered will be distributed pari passu amongst all the secured creditors, irrespective of what security they were holding prior to the relinquishment. So a person having a security over plant and machinery and a person having a security over a car or a computer, when they relinquish, they will be pari passu. So that is what the logical conclusion of the NCLAT judgments are, which is also pending before Supreme Court. And the last are the assenting financial creditors who anyways vote for the plan, and whatever is being given to them will be distributed to them as per the distribution mechanism approved by the COC in their commercial wisdom. The Supreme Court has in n number of judgments established that the domain of distribution and approval of a plan is completely within the domain of commercial wisdom of the COC. So the COC can come up with any distribution mechanism for the assenting creditors. It could be taking into account 53 simpliciter, that whatever is as per 53 will be distributed. It could be as per the claim value. It could be, we have seen formulas being given that, okay, 90% for secured financial creditors, 10% for unsecured financial creditors who assent to the plan. The idea is that it's a commercial negotiation, and to gather the majority so that the plan goes over the finishing line. Typically, preference shareholders and equity shareholders who are there in the waterfall mechanism under 53 towards the bottom are not given anything under a plan, because the money is not enough in most cases, and as the IBBR records show, the recovery has been between 29 to 33%. That is the average recovery from all the CIP processes put together. So the recovery is not even enough to pay off all the creditors, and that's why there is nothing left for the shareholders. And that's why under most plans, preference shareholders or equity shareholders don't get anything. So they are not there in the waterfall mechanism as such for a resolution plan.
Thank you, Madhav, for that great insight. Moving back to Kunal. Kunal, if you could elaborate on the fast track corporate insolvency resolution process and how it helps the micro, small, and medium enterprises.
Yes. So fast track in insolvency guided by Chapter 4 of the Insolvency and Bankruptcy Code, which has 4 sections, section 55 to 58. The said provision became enforceable on 14 June 2017. And IBBI also notified the regulations in respect of fast track on 14 June 2017. Now, question is, who can apply? The creditor, that is the financial oblique operational creditor, can apply, or a corporate debtor can also apply for the fast track process. Against whom is it applicable? It is applicable under section 55 to such companies which may be notified from time to time by the central government. Now, central government has notified these companies as companies whose paid up share capital is not exceeding 50 lakhs, but it's between 50 lakhs and not more than 10 crores. So 50 to 10 crores, and turnover is between 2 to 100 crores. So that is where the application is. One of the major differences between fast track and the normal process is that the fast track process is a 90-day process, extendable by another 45 days. COC voting is at 75% instead of 66% in the normal process. And the resolution professional has been given the power to change the mode of resolution. That is, wherever he feels that a particular corporate debtor cannot be put into that process of rehabilitation in the fast track mode, he can change the process to the normal CIR process, which is Chapter 2. And all the other provisions of duties of the RP, how COC is to be formed, etc., is applicable from Chapter 2 to this chapter also. So that is really the process of fast track. What are the necessary documents? Which is under section 57, necessary documents are proof of existence of default and such other information which may be necessary to prove your case, like a contract or such documents. Coming to how it is beneficial for the MSMEs, of course, the cost is very low. The time period is half, which is 90 days and 45 days. Administrative burden is much less. It is less complex for medium, micro, and small companies. And of course, it gives a lot of boost to the MSMEs. So that's how I think the fast track really works well for MSMEs.
Thank you, Kunal. Let's circle back to Yogendra. Yogendra, if you could explain the recent Supreme Court judgment in Sundaresh Bhatt, liquidator of ABG Shipyard versus the Central Board of Indirect Taxes and Customs.
So, Supreme Court in this decision has decided 2 important questions. One was the overriding effect of IBC over the Customs Act. And second, whether the Customs Department was empowered to initiate or take action against the corporate debtor at the time of moratorium, which was in force in terms of section 40, read with section 33(5). Now, just to start with very relevant facts, what has happened in this case is that the corporate debtor is into shipbuilding. They imported certain raw materials on EPCG license. These raw materials imported from outside were cleared to be warehoused in the custom bonded warehouse. So when you clear it for custom bonded warehouse, you are not required to pay duty, customs duty. The corporate debtor did not file bill of entry for home consumption, wherein the liability to pay custom duty would arise. Thereafter, the CIRP was initiated against the corporate debtor. Once the CIRP was initiated, after that, Customs Department started issuing show cause notices proposing customs duty demand against the corporate debtor. Then liquidation was ordered. After the liquidation was ordered and liquidator was appointed, the liquidator wrote to the customs department requesting that whatever raw material is lying in the custom bonded warehouse at various locations, custody of the same may be handed over to the liquidator, because liquidator was empowered under the IBC to collect all the assets of the corporate debtor. The request of the liquidator was rejected by the customs department. Being aggrieved, the liquidator filed an application before NCLT requesting for custody and ownership of the goods lying in the custom bonded warehouse. The application was allowed by NCLT, directing the customs department to release the goods and allowing the liquidator to take possession and control of the goods. Aggrieved by the decision of NCLT, the customs department went in appeal before NCLT. NCLT, by the impugned decision, reversed the order passed by NCLT, holding that Customs Act is a complete act in itself, which prescribes the process for relinquishment of title in the goods. Considering that it was held by NCLT that the corporate debtor has relinquished the title in the goods, and hence the title vests with the customs department. Against that decision, the liquidator filed an appeal before Supreme Court. Supreme Court framed two questions and answered these two questions in favor of the liquidator, holding that once a moratorium is ordered, it will continue under Section 14 during CIRP, as well as during liquidation under Section 33(5). And since the moratorium was in operation, Customs Department could not have taken any action to initiate recovery against the corporate debtor. The Supreme Court also held that Customs Department can very well assess and levy custom duty along with interest, penalty, fine. But as far as recovery is concerned, that cannot be done during the course of moratorium. Second important question which is answered is giving effect of the overriding provision of IBC over Customs Act. So in Customs Act, after there was a provision which clearly empowered that the customs authorities will have first charge on the demands created under the Customs Act, subject to other enactments, which included few provisions of Companies Act, SARFACI, and after the IBC coming into effect, the same was amended and IBC was also included, meaning thereby that Section 142A in Customs Act gave way to the provisions of IBC. In addition to that, court also noted the overriding effect of IBC under Section 230A and held that the IBC will have overriding effect over customs. So this is the judgment. Now, coming to the impact of this judgment, by the impugned decision of NCLT, the customs dues, that is the statutory dues of the government, were in a way placed at the priority as against the fifth place as mentioned under Section 53 of the IBC. By Supreme Court judgment, they are again placed back at the fifth place.
Thank you, Yogendra. There is a question from the audience. If you could answer, Kunal. IBC or RERA? Which is the best solution for a home buyer to settle disputes with builders?
Yes. So let me divide this answer in two parts. Legal, how do we stand legally today? And my view on where one should go. Legally, where we stand is that IBC and RERA have been held to be parallel to each other. That means that you can approach for insolvency under the IBC, and at the same time you can approach RERA authorities for resolution of your disputes. IBC looks at a larger issue. RERA looks at probably a single project issue. Lately, there have been some judgments where the adjudicating authority and the NCLAT has also held that they can also look at project-wise insolvency process. Now, so that's where we stand as far as IBC and RERA is concerned. Both are available. Just digressing a bit, in fact, Consumer Protection Act is also available. So, in effect, what happens is that if supposing there are 100 home buyers in a particular project, 20 go to IBC, 20 go to RERA, 20 go to or 30 go to National Commission under the Consumer Protection Act, and remaining 40 just look from the outside as to what's happening. So that's where we stand. There was a judgment of the Supreme Court of Justice Sikri in Bharti Airtel where they considered the issue of competition commission vis-a-vis telecom regulatory authority, and the issue was basically as to which one will prevail. If there is a competition issue in a telecom sector, who should answer that competition issue? Should it be an expert tribunal or a regulatory body like TRAI, or it should be the Competition Commission? The Supreme Court said that since there is an expert available, which is in the nature of Telecom Regulatory Authority of India, it is for them to first look at any issues pertaining to a sector, and then probably they can assist Competition Commission to thrash out all the issues relating to competition in that sector. Now, I draw guidance from that judgment because ultimately Real Estate Regulation Act is the real regulatory authority, or I can say body which is empowered and which is also empowered to take over projects and build it to the last extent. So that's the real authority which can really answer all these issues. According to me, IBC is not really the answer or the place where the home buyers should be going, because ultimately what happens is that you would only look for a buyer through a limited scope, whereas RERA would look at it from a larger scope. So that's my view. So legal is one thing, and my view is another thing.
Thank you, Kunal. We are at the end of our session, so I'd like to quickly take your closing comments from everybody. So what is the impact of the IBC and how does the future look like? Yogendra, going with you.
As far as IBC is concerned, to my understanding, the future will definitely be good. The reason, according to me, is that the legislature and the judiciary both are taking endeavor to make IBC successful. The reason behind saying so is that in the recent past, as we discussed, we have seen so many amendments as far as IBC is concerned. Some of the amendments came on account of judicial interpretations given by the courts, and some of the amendments came suo motu. On the other hand, if we see the judiciary is also taking and making endeavor to make it successful, the aims and object of IBC successful, because there are instances wherein the issues are referred to larger bench so that the controversy is resolved and the issues are streamlined. There are judgments by courts which holds very clearly the correct interpretation of the court. So to my understanding, these two legs of the state are taking care of and making provision for a better implementation of the code.
Thank you, Yogendra. Madhav, your comments?
Yeah, thanks, Kaustubh, and thanks, Yogendra and Kunal. It has been a very enriching session, and even I have learned a lot of perspectives and other things from this session. So, as far as IBC is concerned, what we were discussing prior, like at the beginning of the session as well, one major advantage of IBC as a statute has been that the judiciary has been very proactive, and we have seen so many Supreme Court judgments coming on various issues and resolving issues and giving finality to issues, which in other statutes we have seen takes 5, 7, 10 years. IBC is what, a 5.5-year-old statute, and we have already seen more than 100 Supreme Court judgments dealing with various issues of IBC, and that has given that impetus to the statute for a proper development. Now we have seen some aberrations as well in the development, and hopefully the courts will be corrected either by parliamentary intervention or by judicial intervention in the future. But the main advantage has been, as we discussed in the beginning as well, that it has changed the way businesses are run because of that looming threat that you cannot take a creditor for granted in India, because there could be delays in admission, there could be delays in resolution, but at least the threat of IBC where there's an immediate impact on the business going away from your hands is looming large in the Indian business community. And there are many small businesses that we have seen, we have read it about in newspapers, which have come forward and proactively settled with their creditors. And that is something which will be beneficial. So these are just the beginning, although it's almost more than 5 years old, but we must be cognizant that every development or every advancement takes time to have an impact on the economy as a whole. So it's been one 5-year plan has been ended with IBC. Now we are entering into the second 5-year stage, where we will see the seeds sown by the judiciary and the parliament in laying IBC bear fruit, hopefully. And it will be a solution for the NPA problem, which has been looming large. One other thing, like in the US, we all of us have seen various US shows, the legal shows, and even other shows where Chapter 11 is used. So Chapter 11 bankruptcy is where a person voluntarily enters bankruptcy for settlement of debts. Now in India, bankruptcy, or as we say in Hindi, Diwaliya Nikalna, used to be a stigma for a businessman. But hopefully that mindset will also change gradually, because what IBC is giving is that it is a legal mechanism for you to come out of your debts, because you as a businessman, you may take several decisions, not all of them may bear fruit. Your business is linked to various cyclical things, not only domestically, but globally. So prices rise, prices fall, demand rises, demand falls, and that may have an impact on your business, because you may take credit today, but 3 years down the line, that raw material you are producing may have no market. So that is how businesses work. And that is what is required, the mindset that you can enter a mechanism and you can come out of it. The government has introduced various other mechanisms, like we spoke about fast track for small businesses. There is a pre-packaged insolvency as well for MSMEs, which is basically the same thing what I'm talking about, that you can enter into a negotiation with your creditors and come out of it to survive. Because the whole point is that a business and a businessman both have to survive, but not at the expense of their stakeholders. So IBC is trying to bridge that gap, and hopefully right now it is more of an adversarial process, but hopefully, like in the US, it will become more of commercial process to revive businesses, and that is what we sincerely hope is the future for IBC.
Thank you, Madhav. Kunal, your closing comments on the impact of the IBC and the future it holds.
Well, I think Yogendra and Madhav have put it really well in their closing comment. I really have nothing to say, except that there's one point that we must educate our audience on, is that now the promoters are aware that there is going to be a third party which is going to look into your accounts and come out with any fraud or preferential payments made by you as a promoter to a third party, and which will lead to various other issues for you as a promoter. So I think IBC is here to stay. Those ironing of creases will keep happening, and it is only good for us that it keeps happening. I think I leave it at that.
Thank you, everyone. And the valuable insights that you have given have surely elevated our audience. Take care and have a happy weekend.
Thank you, Kaustubh.
Thank you, Kaustubh.
Thank you, Kaustubh.
Thank you, Kunal.
Thank you, Madhav. Thank you, Yogendra.
Thank you, Yogendra.
Thank you.
Bye-bye.
Bye.